A curious fact about patents is that most of them are never used. Over 90% of patented inventions are never commercialized, and less than 1 in 10 that are commercialized are commercial successes. So more than 99% of patents are actually commercial failures. Your copy of the patented invention does not have to be identical to the invention that's patented in order to infringe. If it's substantially similar to the patented invention, similar in the way it functions, similar in the way it operates, similar in the results that it provides, you can still be found to infringe under something called the Doctrine of equivalence. So, what if you're unaware that a patent exists, but then you find that you're actually infringing it? You may develop some idea completely independently. You're not copying anyone's patent, but then later someone comes and says, you're infringing our patent. Do you have a defense? The answer is no. The fact that you were unaware of the patent is no defense to patent infringement. You could still be liable for damages for infringing the patent of another. This is a little bit difficult because there are millions of patents listed at the Patent Office, and checking and tracking them all is very, very difficult to do. You don't have to make the patented invention in order to infringe the patent. You can infringe directly if you make, use, or sell the invention. Walmart infringed Philips' patent by selling DVDs that it sourced from Asia. So, contributory infringers are also liable. You could be liable for infringement if you supply a good that can only be used in an invention to infringe that invention. And if you induce others to infringe, you could be liable as an inducing infringer. So, being liable for patent infringement damages extends way beyond just the people that build the patented inventions. Anyone in the chain of distribution and anyone that's supporting the chain and the sales of these products can be found to be an infringer and hailed into court. One of the curious things about patents is that they do not provide the owner with the right to use the patented invention. The owner is provided with the right to exclude others from using the invention. You can't guarantee that your patent does not infringe someone else's patent. Let's say you invent a bicycle and you get patent protection on the bicycle. This means you can exclude others from making, using, selling bicycles. However, the bicycle wheel may be patented and owned by someone else. So you're unable to actually use the patent yourself, your bicycle, because it involves infringing someone else's patented invention of the wheel. Now, the difficulty here is that the Patent Office contains millions of patented inventions, and checking and cross-checking where the overlaps may occur will be very, very difficult. The other difficulty is that there are many new applications that are not yet published and made available in the public domain. And you don't know if one of those new applications is issued if it then overlaps with your patent. So it's impossible for you to guarantee to a potential licensee that your patent does not infringe someone else's. You can't license the rights to use your patent. You don't have the right to use the patent. What you have is the right to exclude others from using the patent. So what you can do with a licensee is promise not to enforce your patent rights against them. This is what a patent license looks like. It's a promise not to enforce. Even issued patents that are valid may be unenforceable in court. The court, in looking at the actions of the patent holder, may refuse to enforce the patent rights. For example, if the court sees there's an anti-competitive use of the patent holder's monopoly power, it may find an antitrust violation and refuse to enforce those patent rights in court. It could also find that the company is tying its patent license to other commercial arrangements, thus trying to extend the scope of its patent rights. This is known as patent misuse, and the court may again find the patents unenforceable. Congress has decided that certain medical procedure patents are not enforceable. So there may be valid patents, but Congress has prevented the courts from enforcing those patents against doctors who are treating patients. Take care when drafting letters to infringers. If you come across a potential infringer, it's in your interest to write a letter, because once they're on notice that your patent exists, they are then on the hook to pay higher damage costs to you in the case of a patent lawsuit. However, in the letter, you don't want to actually accuse them of infringement, because this could give them the opportunity to bring the suit against you before you bring the suit against them. And if they do that, they're likely to bring the suit in a federal district court that's convenient to them, not convenient to you, and probably a court that likes to invalidate patents. So be very careful when drafting the letters to infringers. It's important to put the world on notice that your invention is patented. If you don't mark your patent number on the invention, you may be unable to collect damages for potential infringement from the period that the product did not have the patent number marked. So it's important, wherever possible, to put the patent number on the invention and provide notice to the world that this product is protected by your patent.